first things first, the car seat. It's not with the evidence yet. What is the plan?
It's not, Judge, and we wanted to have a discussion about that. The reason it's not with the evidence right now is it's foreseeable that the jury might ask for an additional jury view, and replacing that car seat in the vehicle would be challenging. I don't think that we have a strong position one way or another, but we thought we should at least have a dialogue about it. I can have my investigator quite easily before Monday get that car seat if we need to have it back returned to evidence. Of course, if they insisted on a further jury view, it would become a very complicated process to have the precise measurements and replacement of that car seat. So we didn't want to do anything without further guidance from the court and without having a discussion with the defense about whether it's more important to leave it with the vehicle at this point or more important to have it with the evidence. I'm gathering from what I'm hearing from Mr. Kilgore, he would prefer to have it with the evidence, and if that's the case, no problem. We'll just have my investigator go to the secured storage location and get it and have it brought back, with the understanding that that might complicate things if the jury sent out a note at some point and says, well, we want to have a further jury view.
Well, there's a whole lot more to the jury view than just a car seat.
There is.
There's a tow truck, all the security, and everything that we have gone through. So I think the better practice is to bring the car seat here, and if they ask for it, we'll be in court, there'll be a big discussion about what to do, and then whatever is ultimately decided is what we will in fact do.
Right.
All right, so you will bring the car seat Monday? Any objection by the defense?
No, ma'am. That sounds like a great idea. Thank you.
All right. Let's see, I guess we have to wait on verdict form. No. I prepared a verdict form. I know there's some requests for lesser included offenses, and we haven't had hearing. No decision has been made on that, but other than that, has anybody had a chance to look at my verdict form, and are there any observations anyone would care to make about it?
The verdict form that we've been provided with, the only thing that Ms. Treadaway noted and pointed out, I missed it quite frankly, on page 2, count 6, after the 2, it probably just needs to be a colon instead of a semicolon. It's just a minor error. Other than that, we believe it's a satisfactory verdict form that looks fine to the state. Bless you.
Oh, okay. Count 6, criminal attempt to commit a felony, comma, to wit, and it needs to be a colon, not a semicolon?
Yes, ma'am.
Okay. Okay. But other than that, it looks in proper form?
State has no objection to that form.
Okay. And as to the defense, pre-permitting whether or not I include something, do you have any problem with this as it stands?
As it stands, obviously we do have some issues with lesser included that we'll be discussing here shortly, but otherwise it appears to be in order.
Okay. Okay. I think you all received the preliminary work that I did with my staff attorney. I think she gave me copies of what I had done yesterday. I wouldn't mind, just as a beginning step, working from the comparison sheet she did, and then we can start moving through the request to charge. Do y'all have that in front of you?
2-page sheet, yes, ma'am.
Yes, ma'am.
Okay. It seems to me that both parties agree that 1.210 will be given. Is that true?
Yes.
Yes, ma'am.
And moving down, both parties agree that 1.31.10 will be given.
Yes, ma'am.
Yes, ma'am.
1.3130 will be given.
Yes, ma'am.
Yes, ma'am.
1.3140 will be given.
Yes, ma'am.
Yes, ma'am.
Now, you know we're going to do all this and you're still going to get confused, but I'll do my best. 1.3140 3142 will be given,
Yes, ma'am.
Yes, ma'am.
and then 13145.
Yes, ma'am, though that may be the one, if I memory serves, it needs to be tailored a little bit to the actual forms of impeachment, but yes, we agree, generally it needs to be given.
Let me then just, let's not do that. And let's put it in for discussion.
And similarly, Judge, I presume it'll be obvious, there are several notes that are attached, annotations that are attached with the pattern charge that certainly aren't a typical part of the charge. They're still in there now, and I'm sure we're gonna take them out. We just wanna, when we get down to that point of finalizing what it's gonna look like, make sure that's covered.
Are you talking about the one that I'll send out to the jury?
Yes, ma'am.
Yeah, it'll be cleaned up.
Very good.
Of course, y'all sent my staff attorney away, so thank you very much. So the cleanup crew is, bless her heart. She's gonna get here first thing Monday, and hopefully we'll be in good shape that while y'all are giving your arguments, she can get everything together and I can review it with her, hopefully at lunch, and give you all a clean copy before I do the charge in the afternoon. That's my plan. All right, moving right along. It looks to me like you have to move mid-page. 1.34 is by agreement.
$1.3400.
Yes, ma'am.
I have a question mark on mine.
Please. It's one of the ones that you asked for.
Right. Oh, that's just another one of those where there's just some extra language that I presume will be taken off, the note that's attached to it.
We'll talk about it.
Thank you.
1.4110 is by agreement. True and.
Yes, ma'am.
That's correct.
1.4111 by agreement.
Yes, ma'am.
Yes, ma'am.
1.4140 by agreement.
Yes, ma'am.
We have just a moment to catch up. Yes, ma'am.
Go to the next page. That's all I see. Agree or disagree?
I agree. Well, with the exception, I've provided that additional instruction. I did give a copy of that to Defense Counsel, Mr. Kilgore. I'm not sure if there's agreement there, though. I think it's appropriate. That would be pattern charge 1.32.23.
I've only got on this sheet those things that were given preliminarily.
Yes, ma'am.
I plan on taking the extra things separate as a standalone,
Yes, ma'am.
and there may be agreement or not.
Yes, ma'am.
So we can do it that way.
Was the last one you indicated 1.4140? Okay. I have it out of order. It's page 55. Some of these are not in order as they're on the list, but it's in there. That's why I didn't put it right in. Okay, very good. Just want to make sure I had not missed it.
Are you okay with that?
Yes, ma'am.
All right. The state's request to charge, the first one, I'm gonna do this a little eccentrically, and I don't know if it's gonna work well or not, but let's see if we can do it the way I wanna do it. State's request to charge number, the first one on my comparison list is 1.10.10. Any objection by the defense?
No, ma'am.
State's request to charge 1.10.20. Any objection?
No objection.
.2010 is by consent of both parties. 1.20.10 is by consent of both parties. 1.20.10 is by consent of both parties. 1.20.11 is by consent of both parties. 1.20.12 is by consent of both parties. 1.20.13 is by consent of both parties. 1.20.14 is by consent of both parties. 1.20.15 is by consent of both parties. 1.20.16 is by consent of both parties. 1.20.17 is by consent of both parties. 1.20.18 is by consent of both parties. 1.20.19 is by consent of both parties. 1.20.20 is by consent of both parties. 1.20.21 is by consent of both parties. 1.20.22 is by consent of both parties. 1.20.23 is by consent of both parties. 1.20.24 is by consent of both parties. 1.20.25 is by consent of both parties. 1.20.26 is by consent of both parties. 1.20.27 is by consent of both parties. 1.20.28 is by consent of both parties. 1.20.29 is by consent of both parties. 1.20.30 is request to charge 1.20.30. Any objection by the defense?
No objection.
I think that on Jen's comparison, the next one we should, oh no, I skipped it. There's defense 1.2020.
State has no objections.
All right, that gets us down to 1.30.10. Any objection by the defense?
1.30.
10 evidence
Oh,
charge.
evidence, no ma'am, no objection. I'd already checked it, I apologize.
No problem. And the next one is 1.3020.
State has no objection.
We can drop down now to 1.3145, if I'm not mistaken. Because we're all in concert on those.
Yes, ma'am?
Bear with me. I don't have a pencil. Do I have a pencil?
Mhm.
Yeah, that's perfect.
Judge, I'm sorry to interrupt, but can I make an inquiry? We're working on the car seat right now.
Yeah.
We made arrangements to be able to retrieve that, excuse me, that car seat by 3:45 today. We may be done by then. If that's the case, we would like to keep that in a secure location at our place where we'll be staying here. Though there's been a previous discussion about that, so I want to make sure that everybody's in agreement with that. We may have limited ability to get it back into the courthouse if we're done by then.
I expect the courthouse is gonna be open until 5 o'clock, and all the
Yeah,
evidence is secured in here.
Brian may be gone.
He may be, but my understanding is the evidence stays here and is secured in this room, locked up, so I think they probably, my guess is we'll still be here at that time, but if we're not, I think there should be, we can get it into this courtroom and secure it.
I'll
so
ask,
they don't have to
I'll
worry.
ask for an update at about 3:45.
Fine with me. Okay. 1.3145, impeachment.
I think we both agreed on that, I believe.
Yeah, I thought y'all said it needed some tweaking. This one doesn't though.
What page number would that be for your instructions, Judge? I'm having a hard time finding it.
17, I think.
Oh, I see. Yes, that one does not need to be tweaked, so to speak. You're correct.
Okay. I hope we're not dealing with different versions of the pattern jury instructions.
Well, there is a separate impeachment that deals with different ways that a witness can be impeached.
There is. But it goes back to 1.3140, which you all agreed to. That's on page 8. My update is of July 2016. They're updating them pretty regularly, and they're updating them online, but I'm going from the hard copy from this summer.
My page 8 that I have from what was provided us is direct and circumstantial evidence.
Oh, that's wonderful.
Page 8.
What does the bottom of your page say? When does it say it was updated?
It does not. It just says, page 8, the top of it is direct and circumstantial evidence. No updated state on it.
Well, that gives you a lot of deniability.
Yes, ma'am.
Oh, okay. I just love this.
What is
Okay, well, let's just go by the bullet point numbers. And let's not do pages. You shouldn't have started us on that, Ms. Evans. You took us down the wrong path.
I am at fault for this. Yes, ma'am.
Yes, you should be embarrassed.
I'm terribly embarrassed.
All right. Let's go back to 1.31.10. Let's just do that. And that's general evidence charge. We're all in agreement, right?
1.3110?
Oh, I'm sorry, 1.31. Hey, that may be the mistake. I may have wrongly chastised Mr. Evans. Okay, let's go to 1.31.10, which is on page 6. And that's credibility of the witnesses. And we all agree on that charge, right?
Yes, ma'am.
And that's, now, what page number do you have for that, Mr. Evans?
I have that as page 8, credibility of the witnesses.
Okay, then we're
No,
going
I'm
to go.
sorry. It's a different page number. R6 is judges of law and fact.
Then we're just going to have to go by the numbers.
I have no problem with that.
Because otherwise it's going to be an awful
Yes, ma'am.
experience.
I agree.
Okay, then let's look at 131.30, which is going to be expert witnesses. Of course, I'll get that. Let's look at 131.40, and this is the old impeachment. This is the one that probably needs the tweaking. So let me just start reading it, make sure we all have the same copy in front of our faces. In determining the credibility of witnesses and any testimony by them in court, you may consider, where applicable, evidence offered to, I don't like attack, and I don't like cast doubt upon. How about challenge?
No objection.
We're fine with removing attack. I think we would request you say cast doubt upon or challenge.
I can do that.
Thank you.
The credibility or believability of any such witness. Is that okay?
Yes, ma'am.
Yes, ma'am.
Including evidence of character for untruthfulness. Do we have evidence of that according to the state?
I do not believe so.
According to the defendant?
Absolutely, Your Honor.
And
We have evidence of prior sworn testimony that's inconsistent with the trial testimony that's been admitted to in part by state's witnesses and proven to be true upon cross-examination.
be more specific.
Stoddard testified at a probable cause hearing as to certain things which he since retracted and testified that he did not testify correctly. There's been specific information from the actual evidence that disproves some of the things were testified at that probable cause hearing, as well as other testimony in other hearings, just as an example.
Well, according to this, it has to be shown by opinion of other witnesses, by reputation.
We've had a specific witness indicate that they did not trust the state. That's about as stark as we can get, I would say.
I'll take argument.
Judge, that's not character for truthfulness. And, you know, I think what Mr. Lumpkin is pointing out in terms of the testimony of Stoddard is, you know, just presupposing that we agree that's the evidence, and obviously we do not. There is a separate portion, I believe, that deals with disproving facts, and that would be more appropriate. But no witness has been called to actually give specific character testimony about the truthfulness of any witness in this case. And that question about why somebody would not want to talk to the state is a completely different question than it has to do with character or truthfulness for any witness.
I'm not going to give it. The next is bias.
I'm sorry, Your Honor, there's a secondary part of that paragraph, if we could address that first. After character or untruthfulness, and there's also or bad acts, which are specific
Right.
instances.
That's what we were talking about.
Yes, ma'am, we covered the first part, but did not get to the second part.
Oh, I thought we covered the whole thing. What else do you want to say?
I did not address the second part, we had not mentioned it, where it indicates or bad acts. Specific instances of conduct of the witnesses in question brought out on cross-examination that another witness may relate to. That witness in question's character for untruthfulness. I had multiple specific instances where there has been witnesses who've come and testified that here's what I saw, it was found, and then upon cross-examination, either they indicated that they did not find it, or there's been other witnesses come in and say, no, that in fact is not true. The state said its own witnesses inconsistent with one another as to testifying what they said they found and what was not found. So I think out of abundance of caution, we should leave that part in.
I think I'll stand by my ruling. Okay, bias.
We have no objection to that.
We would request it.
Okay, so both of you agree to bias.
Yes, ma'am.
Yes, ma'am.
Felony conviction, we don't have any evidence of that. True?
Agreed.
Correct.
Crime of dishonesty conviction, no. So we have to go to the next page. That takes care of all of that, as far as I'm concerned. You see anything to differ with me on?
No, ma'am, I think that's adequately tailored to the facts of our case.
Thank you.
And we agree the remaining part of those 2 pages can be removed.
Okay. Let's go to 13142. In determining witness supported, in determining credibility of any witness whose credibility has been cast down upon and challenged. See, now here I'd be fine with attacked. Can y'all just use attack here? So
I don't have any
so
objection to that, Mr. Pattern.
Your words.
You want to go to the other word and not use the other 2 that you
Yeah.
used previously?
I just want to say attack there.
Well, I'm okay if you want to say attack, but I think so we don't confuse. We've got the exact same terminology. I think that's why it's used, to make sure the jury knows these are consistent with one another. So if you use all 3, I'd be satisfied.
No, I'm not doing that. I'll do cast out upon and challenge, but you do know that consistency is the hobgoblin of small minds. Just an observation. But I'll be consistent, but I'm going to use those 2. As I have described above, in any testimony by him or her in court, you may consider where applicable evidence offered to support the credibility or believability of any such witness, including character for truthfulness. What's the state say regarding that?
Well, let me say this first. I don't have any problem with that first paragraph, just as in a general sense. But obviously, there's been no character for truthfulness testimony, so I think that would need to be omitted.
And I would agree, since we think it should be in the prior charge, that it's not, I think adds to our argument to have it removed from this.
And I think that applies to the second part too. We don't give that.
I agree.
So I don't need to say this would include.
If you remove both of them, that's correct. Obviously, we would ask for the second one to be given as we did before, but if you're not giving it in one, it makes sense not to give it in the other. It would just end at that sentence that ends with witness.
Wait a minute, I am giving bias toward a party.
That's correct, and that would be the last sentence, I believe, of that second paragraph.
Yeah, let's see.
I'm sorry.
This would include
Correct.
evidence of bias toward a party.
That's correct, Your Honor.
Specific instances of conduct of the witness in question that may relate to the witness in question bias toward a party.
Yes, ma'am.
I'm going to give. So then witness supported, and I should give lack of bias toward a party. Specific instances of conduct of the witness that may relate to the witness's lack of bias toward a party.
Agreed.
No
Everybody
objection.
Everybody agree with that?
Yes, ma'am.
Yes, ma'am.
And then 45 witness impeached, it doesn't need any tailoring, and we all agree on it.
Yes, ma'am.
If you've already given the longer version of it, I don't know there's a need for this. I think it's what you had initially indicated, not giving both of them. It's fine if you give it, but I don't think it's necessary.
That may be true. I think better practice is to give it, so I'll give it.
Fair enough.
Now, the next one is not agreed upon. It's one, but it may be, 13147. The defense has asked, and the state did not.
We have no objection to that charge.
Okay, I'll give it. And the next one is 13180. Is there, to whom was immunity or leniency granted?
Yeah, Judge, we could not think of a factual scenario that would warrant the giving of that charge.
Yeah, I was gonna ask them.
Your Honor, Ms. Durr, as you might recall, testified regarding the marijuana that's pervasive throughout her apartment that everybody could smell when they came in, and that she could easily have been charged with that, but they chose not to. The detective then testified, he also indicated they were not there to charge her with the prostitution, that they had her clear cut on. Of course, he denied any smell of marijuana, but there clearly was an indication there, some, at the very least, leniency granted to her to get her testimony.
Well, you don't have a pending prosecution. You don't have a negotiated plea. So I guess it would be a grant of leniency.
Judge, we have no objection to it, just out of an abundance of caution.
Okay. Well, I mean, pending prosecutions, how does that language apply to anything?
I think she was on probation, as I recall, at the time, so technically that could be considered it is a pending case, and that South Cobb County Judicial Circuit looks at it.
Okay.
Yeah, I think it was Cherokee probation, I'm pretty sure.
It was Cherokee, it was someplace else at one time.
I didn't say it was, I was just saying how we refer to it.
I'll give it. 13190. That's the state's request to charge. Any objection by the defense?
No, any objection, that is an accurate statement of the law, we give the statute.
I'll give the pattern, which I think is the statute. 13210, so let's move on.
No objection from the state.
Wait a minute, I'm not there yet.
Oh, my apologies, Judge.
No problem. Okay, 13210, no objection by the state.
Correct.
13215,
No objection from the state.
13216.
I'm sorry, Your Honor, with regards to 13215, I'm not sure that any of this is an actual jury instruction. It
Oh,
appears-
yeah,
appears to just be some commentary.
yeah, so why did you put it in the?
That's a good question, Judge. We'll withdraw it.
How about if I'm not gonna give the I'm not gonna give the commentary stuff anyway.
Thank you.
But if you want it withdrawn, it can stand.
Thank you.
13216.
No objection from the state.
As regards the language that we have there, we left the code section in, it's in parentheses, I just want to make sure it's very clear that won't be left in there. And then I'm looking at the third line there, then the next parentheses says, and if the statement was given in custody, I think if the statement was given in custody can be removed, I don't think there's any question about that at this point. That's a caveat. It's not needed in this case.
Let's be sure we're all on the same page. This is what you're wanting. 13216.
Yes, ma'am.
A statement that the defendant allegedly made while in custody.
That's fine there.
Has been offered for your consideration. Before you may consider this as evidence for any purpose, you must determine whether the defendant's statement was voluntary and whether the defendant was properly advised of his constitutional rights. Is that how you anticipate
That's how we're
the charge?
requesting it. Yes, ma'am.
What is the state's position on that?
It's fine, Judge. We think technically he was detained and not in custody, but again, out of abundance of caution, we don't have any problem with 132:16 as articulated.
Okay, I mean, I think technically, but, okay, I'm with that. Okay, 132:17,
We have no objection to that.
132:18,
We have no objection to that.
132:19,
No objection.
132:21.
Am I correct that that's constitutional rights?
That
Yes.
is.
Okay, no objection to that.
Go down to 132:40. That's going to be burden of proof as to rights.
No objection.
Is it helpful to you, Mr. Evans, if I read out the titles too, because of the difference in our,
I've written them in, just going through the table of contents, so I'm satisfied with the numbers.
because I don't mind calling it out if you need it.
This is a perfectly efficient way from the state's perspective.
No, but that can go down to in a minute.
If it changes, I'll let the court know, ma'am.
Okay, 132:50,
No objection.
132.
I'm sorry, S 132:50.
Yes.
And I apologize, I know it is our charge. The last phrase there that's in parentheses,
Yeah,
I don't think is necessary. Actually, the last two parentheses, except for purposes of attacking credibility of the witness, impeachment.
if you find as mentioned above that the defendant's statement was voluntary, and that all of the warnings to the defendant's constitutional rights were given, that the defendant did understand the meaning of what was said and knowingly gave up such rights, then you may consider it as evidence. If so, you must apply the general rules for testing the believability of witnesses and decide what weight, if any, you will give to any or all or any part of such evidence. If you fail to find the defendant was properly informed of these rights and that he understood and gave up those rights, you must disregard the statement entirely and give it no consideration in reaching your verdict. And these are the parts you're saying you don't want given, except for purposes of attacking credibility of witness or impeachment.
Correct, since the defendant did not testify, his statement was not used to impeach him.
We don't have an objection one way or another. If you want to remove the parenthetical, no problem.
I'm gonna take them out. They are not adjusted to the facts. 132:70.
We have no objection to that.
Are there parentheticals the defense wants to call to the court's attention?
Thank you, Your Honor. The first note there, obviously, you wouldn't be giving, these first full paragraph thereafter is
Whoa,
parenthetical.
whoa. The note is there's no necessity. Of course I wouldn't do that, okay.
Yes, ma'am.
Then the next page, for my view, has something in parentheses.
That's right. That full paragraph, we would ask, that would be given. I think that's correct to give that.
You want it given.
Yes, ma'am.
Okay. Okay, so you should consider with great care and caution the evidence of any out-of-court statement allegedly made by the defendant or by the state. Jury may believe any such statement whole or in part, blah, blah, alone have the duty to apply the general laws for testing believability of witnesses. And the defendant out-of-court statement that is not supported by any other evidence is not sufficient to justify conviction. Proof of other evidence beyond a reasonable doubt the crime alleged to have been committed constitutes supporting evidence. Found that there was a statement made by the defendant supported by other evidence, a degree of proof necessary to convict, satisfied beyond a reasonable doubt. Is that what y'all want?
Yes, ma'am.
All right. State,
No objection.
let us go to 134:00. Limiting instructions. Both of y'all asked for it. There are quite a few notes and parentheticals and such. Why don't we take it line by line? I think, okay, with line one, sometimes evidence is admitted, obviously for a limited purpose should be given, true?
Yes, ma'am.
But I don't think you've got a, for, against against some parties and not others, true?
Agreed.
How about for some counts and not for others?
I think that should be left in there.
Yeah. Well. Which counts, what does the state say?
Judge, this is a tricky area because this involves some argument that we had about intrinsic versus extrinsic evidence, as well as an order that was prepared by the court. I don't know that it's easy to fashion these two charges to account for the court's ruling, which essentially admitted most of this evidence as being intrinsic, but also, out of an abundance of caution, being extrinsic as well. What are your thoughts on this? Want to look at the
Well, why don't we ask them which counts, what evidence applies to?
Well, that is about the tricky wicket because we believe
That's
some of
why I asked
the
you.
evidence does not apply to some of the counts, and that's why we asked for a severance. That's why I believe the language should be in there because it's.
Well, without waiving any objection as to failure of the court to sever the offenses, what evidence do you believe, the evidence that's been admitted for limited purposes, which counts do you not believe it applies to?
We don't believe the.
Let's just say count one, yea and nay.
There's evidence provided that we do not believe applies to count one.
Okay.
Can I make a suggestion to the court?
Sure.
We're willing to take this burden on us because it was our argument, and I believe we prepared the order. I know we've all been frequently checking emails down here, including the court. Could I take a look at these charges, and could we try to fashion what we believe is an appropriate charge to account for intrinsic versus extrinsic, and have that emailed around this weekend in advance of Monday's closing arguments?
I'll have on that. So, one, because I have a funny feeling that there may be more than one circumstance that we're going to need to do that.
Yes, ma'am.
I'm going to work on these Sunday afternoon is my intent, because I figured dust would settle by then.
Well, then no later than Sunday morning, I'll make sure that we have something put together that's going to be emailed out, and we'll use that maybe as a starting point and actually go from the order that the court signed.
All right. Then I'm going to reserve 1.3400, and we'll follow the weekend protocol Mr. Evans has suggested. Any problem with that, Mr. Martin?
But we've had to look at whatever's offered, John. I think we have a simple solution before us, but we'll wait and see if a better one comes along.
Well, and the simple solution,
Are often the best.
but I haven't heard you articulate the simple solution. I've heard you say there is one.
Well, I'm sorry, I thought maybe I said it to myself. Just removing the language we asked and leaving the rest of it as it is.
So what?
Obviously, it was not satisfactory, so we'll wait and see what they come up with. Can we just remove the language of against some parties and leave the rest?
Well, clearly that needs to come out. I think there's agreement there.
Yeah,
Sure.
yeah, that's why I'm going home. Yeah, we've agreed for, against some parties. It's not at all in any way adjusted to this case. We've agreed that for a limited purpose so far my notes are sometimes evidence is admitted for a limited purpose, and then against some parties and not others is not adjusted to facts, and it's agreed to come out. Disagreement comes to for some counts and not others, and that's what the defense wants for some counts and not others, and the state wants that eliminated. So they're going to toy with a suggested adjustment to this charge that is consistent with the evidence and the orders in the case. They're going to submit that Sunday morning. You all can respond. I'll decide. Is that what we're agreeing to?
Yes, ma'am.
They're welcome to do it before Sunday morning if they like, but we'll get it when we get it.
I'll try to do it before then, and I think that we'll be able to accomplish that.
And I know me, when you get it to me, even though I don't want to, I'll start looking at it. But I may decide I'm not going to look at it till Sunday afternoon.
Well, maybe they'll send it to us first and we'll toy with it before we send it to you.
I don't have a problem doing it that way, Mr. Walker.
I think we've done that past and that's worked out well.
I think I gave y'all a lecture about that y'all should confer with one another first, and that I'm your last resort, so.
I vaguely recall hearing that on occasion, but
The court will take note that I have taken the court's instruction to heart.
Oh, I'm delighted. Okay, we have a very odd plan, but it will work. Okay. 1.341, state has asked, the defendant has not.
Judge, I think this would fall in the same category as the other one. This is other crimes, wrongs, and acts. It used to be similar transactions. It's now 404B. Why don't I include that in the prior discussion and see if we can fashion that in accordance with your prior order.
Okay, so y'all are gonna email back and forth and see, even if you can't agree, if you can narrow it down to the issues that are in dispute, and outline for me so I can analyze it and give an answer.
Yes, ma'am.
Send a copy to my poor staff attorney, who's gonna be driving down here on Sunday afternoon, thanks to you guys.
Yes, ma'am.
I think that's a good solution, Ms. Evans, thank you. That brings us down to 134.2, which is a defendant's request only. Let me get to it.
We'll be glad to withdraw that charge, Your Honor.
Prior difficulties,
Yes, ma'am.
you want to withdraw it?
Absolutely. Unless any evidence of any prior difficulties.
$134.50.
Judge, what's the title that you show that to be?
$134.50.
Yes, ma'am.
Limiting instructions, conditional admissibility. Is that right?
I don't see a 134.50 on my table of contents, but I will find it.
Which table are you looking at? Are you looking at the one my staff attorney did?
Oh, I see it there. Yes, ma'am. It's just I have a table of contents for my pattern charges, and maybe it's not up to date. And apparently, they've added a 134.50, and I just don't have that.
What do you look at? Do you have your pattern instructions with you?
I do.
What do you have after 134.20, prior difficulties?
Okay, so 134.20 prior difficulties and 134.30 is prior conviction, and then mine skips to 135.10.
Really?
Actually, my 135. Let's see. Yes, ma'am. Which is identification. So let me pull up an online version of that.
Well, I'll read it to you.
Yes, ma'am.
Sometimes evidence is admitted conditionally. That is, although you have been permitted to hear the evidence, it is only admitted and you may only consider it if you also find certain required predicate facts which allow you to consider such evidence. If you do not find the conditions necessary in order to allow you to consider the evidence, then you must disregard it completely, even though you have heard the evidence. And it cites OCGA 24.1.104B.
We have no objection to that.
Okay.
Your Honor, we ask you to give it as it's provided with the word "but disputed" in parentheses.
Okay. You want to come take a look at this from my book? Because that's a little more language. It would be, you may only consider it if you find certain required but disputed predicate facts which allow you to consider such evidence.
If you don't mind, Judge, that'd be great.
It's the one that she provided to us, so that's been helped to page 16 or 36.
Page 16?
Page 36 of the
Okay.
charge that she provided us, not the book page.
I left the
Thank you,
parenthetical out when I
Judge.
read it.
Yes, ma'am.
Are you okay with the parenthetical?
Yes, ma'am. We don't have any objection.
All right, before we move to the next one,
No. Yes, sir.
the prior charge, before we get too far down the road, 134.20, I'd indicated we wish to withdraw that. My learned counsel pointed out, a matter note that would be applicable, so we would ask that would be given, and it is the pattern charge in the statute.
prior difficulties, correct?
That's right.
Yep.
That's fine, Judge, we have no objection to that. I don't know that there's been any evidence of prior difficulties, but
Well, it is, I mean, okay, here, let's take it step by step if we're gonna do it. Evidence of prior difficulties or lack thereof, parenthetical in or out?
In, Your Honor,
Okay,
that's-
in. Between the defendant and whom? The alleged victim, a witness, which?
The alleged victim.
Evidence is there are difficulties between the defendant and the victim.
That's where the crux is. We agree there has been no evidence of any difficulties between the defendant and the victim, but there's a lack thereof. That's why that parenthetical is so important. That's why it's in the pattern charge.
Okay. So it would not be witness, it's the alleged victim.
That's correct.
What says the state?
we don't have any objection to that, Judge.
Okay. I won't make a reference to a witness, I will only make a reference to the alleged victim.
The only thing that I would point out is that final parenthetical dealing with reasonableness of the alleged fears by defendant of alleged victim. I think that's geared more towards a justification claim, so I don't think that that would be an appropriate parenthetical to leave in.
We'd agree.
Let me read it, I'd like to agree too. Okay. Evidence of prior difficulties or the lack thereof between the defendant and the alleged victim have been admitted for the sole purpose of illustrating, if it does, the state of feeling between the defendant and the alleged victim, period. Whether this evidence illustrates such matters, a matter solely for you, the jury, to determine that you are not to consider such evidence for any other purpose. This is agreed to?
Yes, ma'am.
Thank you. Yes, ma'am.
Um, 14010. Definition of the crime, pattern, any problem?
No objection.
Oh, you know what? No, y'all didn't. Okay. 14110, intent. Any problems? Oh, wait, y'all agreed to that.
Agreed, yes.
Doesn't need editing. 14111, agreed to, doesn't need editing. 141. So y'all don't want presumptions and inferences, 14112? You can ask for it, I won't do it.
Judge, actually, we would ask for that. We should have included that as well.
We can provide a copy of it so we can review it.
Every person is presumed to be of sound mind and discretion, but this presumption may be rebutted. Sandstrom stuff. You may infer, if you wish to do so, that the acts of a person of sound mind and discretion are the product of that person's will, and a person of sound mind and discretion intends the natural and probable consequences of those acts. Now, whether or not you make any such inference or inferences is a matter solely within the discretion of you, the jury. OCGA 1623, and 24, and 25.
We have no objection to it, Your Honor.
And 14130 is accident.
The defense requested that. We have no objection so long as you leave the parenthetical in or criminal negligence.
Okay.
I could find it and
Which one are you looking for? The pattern?
I'm just trying to find the copy that we provided. I don't really have a problem with it. We just, some of these were out of order number-wise, and so I rearranged them. what you provided us by chance?
Page 3. Oh, that, no,
Okay.
that isn't anything.
I will look for it.
You get there.
Page 54.
I think it is. Thank you, Mr. Rodriguez.
54, what I prepared?
Yes, ma'am.
Oh. Oh, you're looking, there are two things I gave you.
Oh, I see.
I have it as 54 as well on my copy.
That's the one that's not a compilation to go out to the children.
That's
Yeah.
it.
Yeah, that's it. That's it,
That's enough.
that's it.
You said something about giving us two things, I didn't know what you're referring to.
Probably I gave you 3. I gave you the sheets that correlated your requests. I gave you all your charges, I think, put together.
Right.
I think kind of ordered. And then I gave you, maybe you didn't get this. Okay, it's a working
Okay.
document for me.
Okay.
I will give you this. This is, I intend to charge them, and I intend to give them a written copy of the charge. The preliminary things and the final things, I'm not going to give them how to deliberate in a written charge. I'm not going to tell them I'm going to read them the bill of indictment in a written charge. They're going to have it with them. So those things are going to be edited out, but the meat of it, the substance of it, I'm going to give them. And as soon as I can get with my staff attorney to get that together, I'll get y'all a written copy of that.
Okay.
All right. 14140 by agreement. 14150 from the defense. Any objection?
Just, we don't have any objection to that. It's probably safest to leave it in.
Would agree.
I didn't agree with it all very well, I'm sorry.
I'm sorry, but we agree that it's safest to leave it in, so we're not objecting.
And the parenthetical belongs as well, or omission to that?
I would say yes, ma'am.
Yes, ma'am.
I think. State's charge request now, which will go to 16010.
No objection.
What did I get there? See, that's what I'm gonna give, of course, but I'm not gonna give that to the jury in writing, there's just no reason for that.
Agreed.
If you're going to be charging them and giving them all along, I just want you giving them all of it in writing, would be my 2 cents. They say some of these latter ones, even though they seem very routine for us, may be very important for them. I think because it sets out the burden of proof and form of the verdict, I think that's important enough to get to them in writing.
You're gonna have a bill of indictment, a verdict form. I will have given them instructions on burdens of proof. So I don't intend to do that. That doesn't mean I won't change my mind, but right now, that's not what I plan on doing.
Understood.
Another exception. I tend to be pretty tedious with that one, y'all. You just may as well know I'm gonna take it count by count by count by count. So it can go for a long, long time. Okay. 170, 10. 17010, no interest by the court, any objection?
No objection.
17011, sympathy.
No objection.
17020, sentencing responsibility.
I would object, I know it is a statement of the law, but continues to bother me that we tell them not to think of something and then we tell them about it. So that's my practice, just ask that this not be given so it doesn't create a thought in their mind that we tell them not to think about.
Philosophically, I won't state my opinion, but I'm going to give it over objection. 30. 17030, any objections? Deliberations by the jury? Sorry, no objection.
Correct.
40, unanimous verdict.
No objection.
50, alternate. 60, send them to the jury room.
As to 50, you don't have anything indicated as what the appropriate instruction is, so.
What I usually tell them is, see, all right, so I will have just said to them, whatever your verdict is, it must be unanimous, and by that I mean agreed to by all of you. Your verdict must be in writing. Some point it says there's 12 of them anyway. Oh, deliberations. One of your first duties in the jury room will be to select one of your number. Type this foreperson. Bear in mind your foreperson will preside over your deliberations and sign the verdict to which all 12 of you freely and voluntarily agree. Blah, 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 blah. Then you go to alternates. And then I say, well, I know y'all can count. And I know when I told you there were 12, you were saying, but there's 16 of us. And that's a true statement. So 12 of you are the jurors and 4 of you are the alternates. And then I tell them that it's the responsibility of the bailiffs to ensure that the alternates are kept separate and apart from the jury during deliberations. And it is the responsibility of the foreperson to ensure that at all times during deliberations, all 12 of the seated jurors are present in the jury room when they are deliberating, but that none of the 4 alternates are in the jury room when they are deliberating. And I call their names out. And that's generally how I do it. Was it long? Do you have a problem with that process?
I don't. I might ask you to add, however, that those 4 when they are separated are not discussing the case or doing their mini deliberation on their own.
I usually also tell them that when they have their lunch together, when they have a break or lunch together, they can be with each other, but they're not to talk at all about the case.
Very good.
Okay. Let's get to 1010. Any objection by the defense?
210.
Homicide, malice,
The
murder.
definition of malice murder.
Mhm.
Do not have an objection to that.
I'm sorry, back up. It's 20110.
Yes, ma'am.
Okay, well, wait a minute.
That's not what I have.
I don't see a 20110.
That's,
210.
Let me back up. 20110 is attempt.
Ah, yes.
Okay. Do you have any objection to that? It's going to have to be put in a different order. The attempts charge is 6. So I'll have to go with instructions on 6.
yes, ma'am. And in our request charge, you'll note that it suggests that you put the named offense. That would be sexual exploitation.
Yeah, I'll fix that.
Yes, ma'am.
I think that maybe Jen put it this way because she's following the way it's listed in the pattern jury instruction. So I'll do some adjustment. It's a person, just to help you if you're not there, Mr. Lumpkin, it's
I found it.
did you, a person
Yes, ma'am.
has the criminal attempt to commit sexual exploitation of children when with intent to commit sexual exploitation of children, that person performs any act that constitutes a substantial step toward the commission of the crime of sexual exploitation of children. And then I'll need to define that crime.
Don't have any objection to the attempt language. When we get down to the point of defining what that is, we may have some issues when we get there.
Perfectly reasonable. 20-10-10, the malice murder charge. I think you said you were okay with
Yeah,
it.
we do not have an objection to that.
Let's turn to our next page.
Judge, I'm technically withdrawing that one. I always include this because I find that juries sometimes want to ask about premeditation, but there's actually a parenthetical that suggests you shouldn't give it outright. I just mostly wanted you to have that at your fingertips should you need it. So unless the defense wants it, probably the safer route would be to follow the language of the parenthetical that suggests that you don't give it outright.
Oh,
We would agree with that.
20-10-12.
No objection.
20-10-20. Felony murder.
Again, it appears, most of this is the note. I think it appears to be there's one paragraph,
Yeah.
and I believe
Person
that-
also commits the crime of murder when in the commission of a felony. That person causes the death of another human being with or without malice. Under the laws of Georgia, the offense of
first degree and second degree child cruelty.
not there. Cruelty to children in the first degree is a felony and is defined as follows, and I'll give that charge. And then the same would apply to paragraph 3, of course. And all the parentheticals are not to be read. Then if you find and believe beyond a reasonable doubt under all the evidence and the court's instruction to defend is guilty of offense of murder, you can also forego, and you must specify such in your verdict form before it could be that the jury find the defendant guilty of malice murder. If you find and believe beyond a reasonable doubt under all the evidence and the court's instructions to defend is guilty of offense of felony murder, you must specify such in your verdict and your verdict could be that the jury find the defendant guilty of felony murder.
Judge, for that, you'll note in the suggested request charge that I gave, I actually put a strike through for those last two paragraphs. I think that's dealing with a situation where they're merely deciding between the greater offense versus the lesser, but since we've delineated them as separate counts, I don't think it's necessary to give those last two paragraphs.
Well, I agree with that. I think it's also going to be duplicative of what I'm going to give them that is to each count.
Yes, ma'am.
Should you find and believe beyond reasonable doubt that the defendant did in Cobb County, Georgia, on or about the 18th day of June 2014, commit the offense of malice murder as alleged in count 1 of the bill of indictment, you'll be authorized to find the defendant guilty. If you do not, however, if you do not find beyond a reasonable doubt that the defendant did commit the offense of malice murder as alleged in count 1 of the bill of indictment, or you entertain any reasonable doubt as to his guilt, it is your duty to acquit in the form of your verdict with the jury finding the defendant not guilty. And then I intend to do the same thing counts 2 plus 3, so I don't see doing that.
Yes, ma'am.
All right, as to this charge, we may want to reserve, final look at it till we get to the lesser included, so we'll be asking.
Sure, that's fine.
That's probably the easiest way to deal with it.
Okay. So 2010-12 is going to apply to counts 2 and 3. Okay, 2010, I'm sorry. 2010-20 is going to apply to counts 2 and 3.
I'm sorry, I didn't catch that, Judge. Which one?
2, 10, 20. I don't know that they improved anything with all these numbers, but anyway, 2, 10, 20, and that's felony murders we were just talking about,
Yes, ma'am.
is going to apply to counts 2 and 3.
I agree, yes, ma'am.
And I'll pull them out and charge them separately, not any kind of mashing it together. I don't tend to like to do that. Okay, 2010-30. Any objection?
I believe it is the pattern charge for felony murder. I was trying to compare it with the one that you just talked about giving.
I think the one before is a predicate. We're setting out the statutory language of the underlying felony.
Don't have any objection to your giving it subject to any changes we may make with any lesser includes.
Fair enough. Okay, let's go to 2/28/21.
No objection. That is the statutory language. Appears to be.
Okay. 2/28/22.
I'm sorry, Your Honor. Under the, in 2/28/21, as to the statute, the indictment does allege in counts 2 and 3, cruel and excessive physical pain. Does not allege mental pain. So we think that should be adjusted to remove that or mental pain from the instruction. That part of the statute has not been charged or alleged.
Okay.
Yeah, I tend to agree, Judge. I don't believe we included mental pain.
You didn't. Count 3, which I guess is going to relate to 2/28/22. And you've got the same situation.
That's correct. There's multiple places that it's in 2/28/21. Should the court will note that.
I'll make every effort, and then I'll let you look over my shoulder too.
Thank you.
I try to be careful and make sure that the charges dovetail with the indictment, because not doing so is fraught with problems.
Absolutely.
Okay, I think that deals with all the pattern instructions, and so now we need to look at the special ones y'all asked for, and then the additional ones y'all asked for. And I'm gonna need a minute to get ready for that, but not long. 1612-100. Any objection by the defense?
Yes, ma'am.
Yes, sir.
The way the state has drawn up the charge in its indictment as to count 6 reads as follows. They knowingly intentionally attempt to commit a crime of sexual exploitation of a child.
Wait a minute.
I'm sorry.
No, don't apologize. Count 6.
Yes, ma'am.
I'm listening and I'm looking.
The latter part of that sets out the attempt of committing the crime of the statute. The accused did, to wit, the accused did request that Chelsea Doster, aka George Girl, 1997, a minor female under the age of 18 years, provide the accused with a photograph and visual medium involving the lewd exhibition of her genital and pubic area, an act which constitutes a substantial step toward the commission of crime. The way the statute is worded, there are 2 ways to commit the statute in 1612-100. There's a Part B1 and Part B8. And what it appears is that the state has done is mashed these 2 together to create an offense that's not actually set forth in this statute. So, I have difficulty in the court explaining to the jury separating 2 parts of a statute that might be a violation and how that applies to what the state's actually accused, which is neither one of those individually. And I'm not really sure how they can handle that. That is why we filed the demurrer, because we saw that on the early part. This was a very confusing point and frankly a improper charge, because it's not actually a violation of the statute as they have it worded.
What says the state?
Really what's charged here is not the completed act of sexual exploitation, it's criminal attempt. And we have all the elements of the criminal attempt. And then we have referred to the sexual exploitation, which is covered by both B1 and B8, which is why in our request to charge, you'll note that we omitted portions of the statute but only focused on B1 and B8, because what the defendant was attempting to do was to employ, use, persuade, induce, entice, coerce a minor to engage in the violation of this act, and in Part 8 to possess, therefore, a minor depicted in this state of undress. So he was attempting to do both a B1 and an 8, which is why we refer to both code sections. And they're using conjunctive, disjunctive rules and things like that. We've actually included both. But really, the criminal attempt is the offense that's charged. We're just referring to the code section, and this was properly addressed during the demurrer, and you essentially ruled. But we think it's appropriate to give B1 and B8 because they're both essentially covered by what we've charged in count 6.
Well, if the state can illuminate us in looking at the indictment where the language is in the indictment that matches the particular code section that they are asking to be charged, we simply can't make it out.
Well, we've already argued this at the demurrer. What this tracks is the language of the attempt statute, and then inserts facts which are consistent with what is covered by 1612-100, B1 and 8.
I just don't see the elements of B1 and 8 in there. I see part of one and part of another.
Well, maybe I can start by making this suggestion. Looking at B1 and B8, in B1, the only arguable portion that wouldn't apply is maybe coerce a minor. So if you wanted to take out or coerce, but certainly employ, use, persuade, induce, entice, that's covered by the facts. So as a starting point, we'll agree that or coerce, maybe that should not be given, but otherwise, based on the facts alleged in count 6 and proven at trial, we think B1 and B8 otherwise should be charged.
The indictment says did request. We don't see that anywhere in the statute. seek to pick and choose parts of this text that they may or may not want to advise the jury of would certainly not be appropriate. And then the 8 alleging knowing possession of, I don't see that anywhere alleged in the indictment.
Well, let's go back to B1. Employ, so the language used in the bill of indictment is request. So it's a stretch to use the language employ. Use, stretch, but persuade, request is in the nature of a persuasion. And reduce is in the nature of a persuasion, and entice is in the nature of a persuasion. So I'm going to strike employ and use and coerce. And use the language persuade, induce, and entice. And if you want to argue about employ and use, I'll listen.
No, Judge, we're satisfied with that.
I'm going to give it over objection.
And we appreciate you noting our objection, and
Do.
we think that's brought there, as the court indicated earlier.
Now, 103, excuse me, 1612 and 103, yeah.
I'm sorry, as far as B8, 1612-100 is the state agreeing that's not applicable.
We're not do that?
We looked at B1,
Yeah.
then they're also asking for B8. I'm not seeing that alleged in count 6.
Possess with control. Well, to ask that someone provide you with a photograph and visual medium is how one would be able to possess or control.
Yes, ma'am.
So I'm going to give 8.
Well, that's the nature of our evidence, Judge, of these computers and these applications, is you don't possess and control those things. That's well settled by the Supreme Court in previous cases. And they didn't allege it.
Well, I'm going to do it over objection, and I think the record is replete with developing these issues for review, and we've got a good record. I'm going to do it over objection. I note your exception for the record. At least I hope we've done our best to have a good record. That's all I can say.
Thank you.
Okay, 1612-103. Will relate to counts 7 and 8. What says the defense?
Your Honor, we'd ask it to, as long as we have it tracking the indictment again, the indictment alleges printed matter containing explicit and detailed verbal descriptions and narrative accounts. Sexual excitement, sexual conduct, which taken as a whole is harmful to minors. So part 2 of that statute certainly is, as we've been provided it with these strike-throughs, that would be appropriate.
Mm-hmm.
As to part 1,
Well, as to A, you've got to take out sell or loan for monetary consideration or otherwise. So it's unlawful for any person knowingly furnish or disseminate to a minor.
Agreed, Judge. I should have put a strike through on the language immediately preceding furnish and disseminate.
so it would read, it shall be unlawful for any person knowingly to furnish or disseminate to a minor.
Mhm.
Okay?
Any photograph or similar visual image of a person or portion of the human body which depicts sexually explicit nudity, which is harmful to minors.
Okay.
explicit and detailed verbal descriptions or narrative accounts of sexual excitement, sexual conduct, and which taken as a whole is harmful to minors.
I guess as to, an account, we have two different counts,
Mhm.
there's two different parts,
Mhm.
so I guess we had to have separate instructions for one for each count.
Yeah. So 16-12-103A1 relates to count 7,
It was count 8, Your Honor.
count 8, so the backwards counter. And then 2 relates to count 7.
That's correct.
Let's see. Verbal description. 7, oh, that's right, 7 relates to sub 2. And 8 relates to sub 1. That's
Yes,
what
ma'am.
I understand. Okay. All right, I'm going to give those. Any objection?
Not with those corrections and having two separate instructions.
Okay. Certainly. Okay, now let's look at the defendant's additional charges, which I may not be able to put my hands on yet, but I may. Well, let's take one right now. Victims' Bill of Rights, right to be present. Does the state have any exception to the defendant's request to charge in that regard?
It's fine, Judge, we don't have a problem with that.
I'm having a hard time putting my hands on. 1, 2, 3. The first 4 of the defendant's request to charge. You all have an extra copy? No?
I believe we've got the, you gave us 2 copies of the, which provides us page 56, 59.
What I put together, it's a
That's
50.
page 56 through 59, I believe it is, Your Honor, what you put together for us.
That might work.
I have an extra copy if you'd like me to provide it to you.
I would be grateful.
Sure. You have that, Mr. Evans?
Oh, well, maybe, no. Good. Got it.
Yeah.
Mhm. these are the ones I have outstanding. Criminal negligence defined further by the defendant. Criminal negligence requires knowledge of the danger by the defendant. Criminal negligence, conscious disregard of the risk by the defendant. Knowledge of the danger further defined by the defendant. I've got defendants request to charge 6, 7, 8, 9, 10, 11, 12, 13, 14. So I'm missing something that I would think must be 5.
That's the one we just went over, the
Was
victim's
that the
bill of
victim's
rights.
bill of rights?
Yes, ma'am.
Got it.
Just filed at separate times, that's why they're.
I know. That's why I'm trying to make sure we all agree before I start plowing through these. Now, I had something up here that somebody just sort of laid on my desk. 13219 burden of proof as to voluntariness, constitutional rights. I think we've done that.
I think the state had added that somehow.
We did, Judge.
It may have been incorporated in what we had, I don't know.
It's a pattern charge, and we deal with the issue of his reinitiating contact after invoking his right. And it occurred to us that when the defense requested all of the requests on statement of defendant, we should have also included that request. So I've provided a copy to the court and the defense.
So what you're talking about is 132.23.
13223, yes, ma'am.
What says the defense?
If I can put my hands on it again, I saw it at one point.
You want me to read it to you?
Here we go. I have
It's a
it.
pattern instruction. 132.23.
Yes, ma'am.
Have you got it?
I have it. As regards as it's set out there in its entirety.
If the defendant exercises any of these rights, such as requesting an attorney, the police cannot question the defendant any further without an attorney being present. Any objection to that?
Objection.
If the police initiate or continue conversation with the defendant after the defendant exercises such right, then any statement made to the police by the defendant after he exercises such right would not be voluntary and would be in violation of the defendant's rights. What do you say about that? I left in all the parentheticals.
That's true, and we're going to complete that sentence.
I'm asking them first.
Oh,
No
the ones who
offense.
asked for it.
No offense.
Don't take it.
That shows wisdom. I mean, it seems like you've got a fact issue, okay, if the police initiate, seems to me the facts might support continue, but not initiate.
Yeah, there's no evidence that they initiated. I think we're withdrawing that request. There. Yeah, no, that shouldn't be given on the facts here. My apologies. Revisiting it after a long day in court yesterday, I now see that that's not applicable to our facts here.
So you want to withdraw?
I will withdraw it, yes, ma'am.
Okay. Well, it wasn't ever formally anything anyway, because it just got stuck on my desk.
Yes, ma'am.
So if I had a transom, I guess you could throw it over the transom, but. Didn't want that. Okay, it stands withdrawn. Problem solved. Now, let's address the defendant's request to charge. Criminal negligence further defined. Any objection by the defendant, by the state?
Yes, ma'am.
Okay.
They're just outside the scope of the criminal negligence. Of note, we have not objected to the pattern charge on criminal negligence, which is 1.40. In kind of similar vein, we've also not objected to mistake of fact. It's slightly different than the definition of criminal negligence, but the next successive series of 4 requests to charge, starting with this one, seeks to expand the definition of criminal negligence, and it would be inappropriate in the state's position to do so, and quite frankly dangerous to stray from the pattern charges, particularly when you look in count 1 that there's even mentioned civil damages, a damage suit. There's additional language there that's not in the criminal negligence statute or pattern jury charge, the statute being 16-2-1. For instance, they've added gross negligence and a definition of gross negligence. Criminal negligence, by definition, demonstrates a willful, wanton, reckless disregard. So there's all kinds of additional language that seek to be added here that would almost seem to heighten the burden that the state would have to reach outside the definition by statute and by pattern charge. So we'd object to request number 1. It's not pattern. We don't think it's appropriate.
Which is the pattern instruction on criminal negligence?
It's 1.41.40.
Say it again, 1.41?
Yes, ma'am.
Are you arguing them all together or separately?
I think they can all be argued all together, but it's the same argument for each of them. The 4th one we think is particularly egregious. It actually gets very specific and is asking the court to charge specifically regarding Mr. Harris's case and comment on the facts and evidence of this particular case, but it's the same argument essentially against all of the other 4. We have absolutely no objection to the statutory and pattern charge on criminal negligence. We think that's perfectly appropriate based on our indictment and evidence presented, but we are adamantly opposed to anything that will expand upon that definition.
Argument?
You know, I think the court's aware that this is the crux of this case, is what is criminal negligence, what does that mean, whether there's been a violation of that. We've seen in questioning by the state some allusions to negligence by itself and not criminal negligence, and thus the confusion has been raised even further by the state's questioning. These are simple statements of the law. I agree there is a statute that talks about it, but what the courts have found is that that is not sufficient, and there has been lots of confusion back and forth by both defendants and the state in understanding what that means. So these statements of the law are from cases that are dealing with that very issue. I think it's probably best just kind of take them paragraph by paragraph. We can see exactly where that comes from, but we would strongly urge the court to take the extra step in this case and make sure we address this clearly. It's going to be, I'm sure, the source of some serious attention in both closing statements by the state and the defense. And if this gets wrong and not made clear to the jury, 1, I think we'll get tons of jury questions about it, but 2, a failure to follow law is more likely to occur, and we can simply prevent that by defining a little further on the front end.
Argue paragraph by paragraph.
Thank you.
Criminal negligence is used in the statutes of the state means not merely such negligence as might be the foundation of a damage suit, but reckless and wanton negligence and of such characters to show an utter disregard for the safety of others who might reasonably be expected to be injured thereby. Go ahead.
Your Honor, that comes from a language in Chapman v. State and Browner v. State. Chapman, the Supreme Court in 1996 was dealing with, in that case, a defendant's attempt to define criminal negligence in a way that they found inappropriate, and the court saw fit to give us exactly what criminal negligence means, even beyond the statute itself, and it has that language. The criminal negligence as used in the statutes of this state means not merely such negligence as might be the foundation of a damage suit, but reckless and wanton negligence, and of such a character as to show an utter disregard for the safety of others, and might reasonably be expected to be injured thereby. That is a clear way to make sure the jury understands that while they may have heard of negligence, simple negligence, and they may have even heard of negligence in a legal setting, criminal negligence is a very distinct animal. And the Browner case was even further specific about that, because it's dealing with a jury charge request regarding what criminal negligence is. And again, the Supreme Court of Georgia specified exactly what they need to talk about. In that case, it involved an accidental shooting with the defense in the case. And the court found that the jury charge that was being asked for was not supported, but told us very clearly that criminal negligence means reckless and wanton negligence of such character as to show an utter disregard for the safety of others who might reasonably be expected to be injured thereby. So I believe what Browner says is the proper jury instruction is this. It wasn't what was requested, so they found that the one that was requested was improper, but it gave us a good definition that we can now give to juries so that we don't have this confusion. So as to that first paragraph, we'd ask that that be given.
All of this is covered by 1.41.40, which is explicit. There's nothing confusing about it. It basically says criminal negligence is an act or failure to act which demonstrates a willful, wanton, restless disregard for the safety of others who might reasonably be expected to be injured thereby. There's no need to give any additional instructions on that. There's certainly no need to compare it to the civil standards. It's very dangerous in the state's opinion to deviate from the approved pattern jury charges that, by the way, it cites to the official code of Georgia annotated 16-2-1. We don't think it's appropriate to expand upon the definition of criminal negligence, which couldn't be more clearly stated in that pattern charge and OCGA 16-2-1.
I find that paragraph in the request to charge by the defendant, request number 1, to be covered by 1.41.40, so I won't give the language additionally. Okay, the next paragraph. It necessarily implies not only knowledge of probable consequences which may result from the use of a given instrumentality, but also willful or wanton disregard of the probable effects of such instrumentality upon others likely to be affected by thereby. Mr. Lumpkin, I heard your articulation. Is there something additional you'd like to add?
I would, Your Honor, and I went to court to the Sullivan v. Kemp case. I think it's notable that was a habeas court where the relief had been denied, and the Supreme Court reversed that because they saw this as a very important issue where the attorney had failed to seek a jury instruction to address this very issue. And with my hands on that, I'll read from that decision. But the language that's there comes from that decision. And I think what's important, not to rehash what I've already said, but to add to it, is that this is talking about what it not only includes knowledge of probable consequences, but also the other wanton and willful disregard. I understand that the statute uses that basic language. The question is, what does that language mean? And what this is telling us is that, in fact, a jury instruction should be requested, that there should be some clearing of that issue up. The Bohannon case is cited above it, Court of Appeals, That was an involuntary manslaughter predicated upon reckless conduct. And that, dealing with that reckless conduct issue and defining it, the court said, well, that's in essence criminal negligence, and thus it's necessary to understand what criminal negligence means. And they gave us, again, this definition to make it very clear why that was important.
Argument?
Judge, it's perfectly covered by 1.41.40. Particularly troubling is they've added a knowledge component here, which is nowhere in 16-2-1 or 1.41.40. While it certainly suggests when you look at the definition of criminal negligence that there is a knowledge component, and we know that that's going to be a source of argument during closing argument. It actually is expanding upon the definition of criminal negligence that's statutory under 16-2-1 and 1.41.40. As for all the other stuff, the willful, wanton disregard, probable effects, all of that is adequately covered by the statute that we're not objecting to, and the pattern charge of 1.41.40. We would object to anything additional to that, particularly when it comes to trying to define knowledge and additional things that are outside the scope of the criminal definition of negligence.
I find it to be covered by the language of 16.2.1 as articulated in 1.41.40 of the pattern jury instructions. But of course, statute overrides anything. All right. Next one. Under our law, criminal negligence may be either gross or willful and wanton. Okay. And that's from 1937. You want to rely on your argument, or do you have more to say?
Oh, Your Honor, I'll add this based on the state's announcement. If the state thinks there's no knowledge component to this criminal negligence, then clearly there's confusion even among the lawyers. We can't understand it. I don't know how we can possibly expect the jurors to understand it by simply giving them this bare bones statute.
Well, there's a whole lot more of the charge, such as intent. So I'm not going to
That's
give
true.
under our law and Kane versus State. And Hurd versus the City of Villa Rica is a civil case.
It is, Your Honor.
So do we want to argue?
It helps flesh out what that definition of gross negligence is, and again, separating it from simple negligence.
Thank you. I won't give it. One engaged in criminal, this is going to be, I believe this will be your second request. Criminal negligence requires knowledge.
We're withdrawing that one, Your Honor.
All right. And the third is conscious disregard.
I could put my hands on it, Judge. One moment,
That my problems are contagious this afternoon.
Again, this goes to the very issue of understanding what criminal negligence is. It's not simple negligence. There is a conscious disregarding that's required. That is a knowledge element, and that we believe that it's helpful to the jury to understand that properly and not be confused, and be able to look at the law as it stands and not be confused by any arguments that might be made one side or the other. This helps elucidate that.
Argument?
It's again covered by 1.41.40. Notably, when you look at this, it's actually, it seems like a minor change, but it has changed the definition of 1.41.40 by substituting the word consciously rather than reckless disregard of substantial risk. And that's the danger and strain from the pattern charge and strain from the statute, is that when you start tweaking with those words, you're now potentially changing the definition of what legally is appropriate. So looking at 1.41.40, criminal negligence is an act or failure to act which demonstrates a willful, wanton, or reckless disregard for the safety of others who might reasonably be expected to be injured thereby is sufficient to cover the gist of number 3, and we're very concerned about adding conscious disregard, which seems to be slightly contrary to what the pattern charge says. It actually requires reckless disregard, which is a different term.
And that's our concern. Recklessness is not defined in that statute. That's what
It
this,
says willful.
that is one of the words. I also use the word reckless.
Well, willful
reckless, willful, and wanton. And then what this is, instruction is defining what reckless is.
But it limits. So I'm not
sure
gonna
limits
get
it
it.
to the law, I'm not sure.
Well, to say only conscious disregard doesn't look to the statute which says willful, wanton, or reckless. And willfulness surely does have a conscious component. I think the pattern covers it, so I'm not gonna get it. Okay, and then I guess this is gonna be 4, which is knowledge of the danger further defined. Okay, what is the authority? But it seems to me, is Elrod and Bolden and Henderson and Milner related to that the statements prove that the crime was committed in the manner alleged in the bill of indictment? That's what it looks to be.
That's correct, Your Honor.
So that would be the authority for your number 4, I don't think.
Well, it is in as much as they have alleged this criminal negligent charge.
Okay, I see your point.
But it is very, and it is very confusing. I certainly have my own problems with it, but this is an attempt to try to make it very clear, which incorporates what the state's been talking about, this car being the alleged murder weapon. We talk about the instrumentality being the vehicle, requiring the state to prove beyond reasonable doubt what is alleged in the indictment. If it's the use of the word Mr. Harris that seems too personal and want to use the word defendant, that certainly makes perfect sense. But it's allowing the court to make sure the jury is actually making a decision based on what's alleged in the indictment, as in this case, not just some general idea of what it might cover.
Argument?
Your charge that you've already agreed to give as a whole already covers this, including how the jury should deliberate what the purpose of the indictment is, the issue that is formed by entering or not guilty plea. What request number 4 is, and there's no authority for it, first of all, is basically an instruction of how they should deliberate and how they should reach their verdict based on certain facts. It's very fact specific if you look at that 3rd paragraph in particular, and it's specifically talking about specific counts, and I caution you moreover, the issue is not whether Mr. Harris should have known or had a duty to know. The statements prove Mr. Harris actually knew the child was alone inside the hot motor vehicle when he exited the vehicle. There's all kinds of things that are added there that are outside the scope of what is already covered by the court's pattern charge. Now, we don't have any objection to the defense making an argument, but they're essentially trying to make their argument through a charge that they're hoping the court will give that jury that will obviously adopt the argument that I expect that they'll be making during closing argument, and that would not be appropriate. We feel the pattern charges as a whole cover this circumstance, and nothing further is needed.
I find it argumentative and I will not do it. All right.
Or we note our objections to each of those, the court's denied the
I
request.
think there's 4 of them there.
That's correct. But
No,
one
you-
of them we withdrew, and we remain 3.
So that makes 3.
Yes, ma'am.
And then 5 I'm going to give. 6, 7, and 8. All stapled together, and 9. So I would take it they're all part and parcel of.
They all rely, intertwine with one another.
Argue.
We were asking for a lesser included offense of vehicular homicide in the 2nd degree. The charge 6 is the request or the jury instruction regarding that being a lesser included, and count 7 defines what vehicular homicide is, particularly with the part of the statute that we would ask the court to explain as part of the vehicular homicide, that being the use of a wireless telecommunication device while operating a motor vehicle. That is defined in charge 8, and then charge 9 actually gives a definition of wireless telecommunications. What this means, Your Honor, is, as has been suggested, particularly by the state's questioning yesterday about whether or not Mr. Harris' use of his cell phone while he was driving the car, texting someone or sending a message before he had gotten to the parking lot at Home Depot, that maybe that was the source of his memory failure, the source of some negligence by not, by doing that and distracting himself, even to the point of claiming a self-inflicted negligence upon himself. While we disagree with the proposition behind those questions, I think it's now in front of the jury, and so we believe it would be proper for the jury to have the opportunity to look at that, because I presume the state's going to be arguing that in some form or fashion, and this allows, if in fact that's what they look at and determine his use of the device while he was driving his vehicle caused him to be distracted and thus left his child in the car, and that's what this statute is specifically for.
It would be lesser included as to which counts.
Good question. That would be as to counts, I believe, count 3 specifically, and the predicate charge, cruelty to the second, which I believe is count 5. The indictment, well, if we go on the side, won't be a predicate, excuse me, it won't be lesser included to count 5, because obviously there's not a death involved in that.
Argument?
Judge, we're not going to argue that this is negligence based upon that one message he sent. That was pointed out to show that he did not, in fact, forget Cooper. He's talking about him while Cooper's in the car after he's alleged that he forgot. That's not the state's argument based on this case. This is a crime that is not a lesser included for this. It would be based on something in a manner that is not charged in the indictment. The manner charged in the indictment is locking the child in the car, not via committing a crime via texting while driving. So, Judge, I don't think the facts or the way this is indicted would support that as a lesser. I don't even know if it could have been indicted separately in a different count that doesn't act as a lesser, but in any event, it's not a lesser included charge in this case. And I think that that would dovetail into request to charge 7 and 8 as well.
I would just.
And 9,
And
sorry.
9, I was taking all of them together.
Yes, Judge. I think that these are all completely an opposite and not applicable whatsoever.
I would just bring to the court's attention C-Volt v. Norris, a 2016 Georgia Supreme Court case, where we just reiterate that a written request to charge a lesser included offense must always be given if there is any evidence that the defendant is guilty of lesser included offense. Just because the state may choose now not to argue it, they introduced it into evidence. They're the ones who brought up the question. They're the ones who suggested it. So to the extent that that's happened, we believe this is now based on the evidence and the court's required to give it. And just because they didn't indict it that way, certainly it's not the standard for lesser included offenses, or if that were the case, we'd never have a lesser included offense.
I find it a stretch, like a big stretch. Probably too big a stretch, but I'll let everybody look at it over the weekend and take it up on Monday.
Thank you.
Since it was filed at 1 o'clock this afternoon.
And what was the site for that case you cited, Brian?
C-Volt v. Norris is 298 Georgia 583. And it was cited last week in Shaw versus the state, S16A 1083. Justice Namias.
Okay. 10.
Is the 10 and 11 go together, as well as 12. Yes. Similarly, we're asking for a lesser included. This is as counts 1 through 3. We're asking the court to give a lesser included of involuntary manslaughter, that being that the defendant committed a lawful act in an unlawful manner, like it caused death or great bodily harm. Specifically, this is very directly addressed to how it's been indicted, leaving the child in a car seat, child alone in a hot motor vehicle, in as much as the issue here is that lawfully Cooper Harris was put into his car seat. He was transported by law, which is state's, defense charge number 12. That it is a requirement that transport a child under 8 years, and it goes on with that statutory language. And the driver is not deemed to be complying with the provisions of the paragraphs unless the system is being installed and being used in accordance with the manufacturer's directions for the car seat. Obviously, it's lawful to put a child in a car seat. It's inappropriate and contrary to specifications and the purpose of the car seat to then leave him in the car seat once you get out of the car. So while it is a lawful act to put him in the car seat, the issue here of leaving him in the car, the factual basis being exactly what's set forth in the case, is that he inappropriately, while committing a lawful act, did it in an unlawful manner by walking away and leaving the child in it. So that's in essence what, again, has been suggested. And what is at issue here is, frankly, what we'd like is there to be some law in the state of Georgia that says you shouldn't leave your child in your car seat when you walk away from your car. And if you do it in one sense intentionally and maliciously, that's how the state's alleging it. But separately, if it should be against the law for you to do it even negligently, that's what this covers. And to the extent the jury may look at this and consider, well, that's what we see as wrong here and should be punished. The involuntary manslaughter based on that, that's the way to get at that. That's one of the ways, at least, to get at that. In this case, that's what the specific violation of law that's involved there, that was done. I say violation of law, it was lawfully done, but then not lawfully carried out when Mr.
Okay,
Harris walked away.
stop. Lawful act is what?
A lawful act is putting the child into the car seat.
Unlawful manner is what?
Walking away and leaving the child in the car seat when he got out of his vehicle. He's still using the car seat and doing the act that the law requires him to do, but extending by walking away.
Without any intention to do so?
That's right.
Why doesn't that strap you back into malice murder? Either intent or there's no intent.
Because
And then all your grave suspicion and all that.
that's an excellent question. That's exactly the point. It was without an intention to do so.
Well, that's a true question.
Exactly. That's why we want the jury to have that option to answer that question that way.
Yes.
Well put.
Believe you're agreeing in argument?
Absolutely not, Judge. Just looking at this 4876 point, or they put point, period B1, in accordance with the manufacturer's directions for such system, we haven't had any evidence of manufacturer's directions regarding this in any way. This is talking about properly installing your car seat and things of that nature. The only thing we have in here regarding anything improper was that Cooper was unfortunately too tall for this car seat. That was in no way alleged as one of the acts in the indictment for causing his death. I just think it's very clear this should not be given in any way as a misdemeanor involuntary manslaughter, lesser included.
Okay, that would be let's just be clear, we're talking about charges 10, 11, and 12, right?
I believe so, yes.
Correct.
Okay, I'm not gonna give it. It's not supported by, it's not supported by the evidence, and it's not supported by the law. Particularly, I think the state makes a good point as to charge 12 relating to all of this, that it's not supported by law. So no, I'm not going to do that. All righty then, 13.
Are you ready for me to? 13 and 14 go together.
If you would, please, yes.
Yes, ma'am. 13 is the instruction on the lesser included. This one is even closer, maybe satisfactory than to the state. This is the particular statute that the Georgia legislature has provided for when a child is left in a deprived condition and it leads to the death of the child, this is the violation of law, which is contributing to the deprivation of a minor, which is 16-12-1. Leaving a child in a dependent state, which would be whether he's been neglected and in need of protection of the court, or is without his or her parent. That's what has occurred in this case, is that Cooper Harris was left without his or her parent, was neglected and in need of protection, thus, which would have provided the necessary protection, so we would not be here today. This is right on point in what the legislature did provide us to try to address this issue as close as possible. Not just this issue, but certainly any time a child is left in a condition of being deprived, then we have criminal charges for that. This is basically, it's exactly what the state has alleged in this indictment, by leaving Cooper Harris alone in a hot vehicle. That's exactly what the statute is talking about, is leaving him alone without his parent, leaving him such that he's deprived and in need. Under the rule of lenity and looking at how this case is alleged, how the facts have worn themselves out, that's really what this would be, even without the necessity of the higher burden of criminal negligence. The lesser charge is that he is leaving the child with the, without an intention to do so, but leaving him as such that he's alone in need of protection. So for that reason, I think this is the closest opportunity we have to get a statute that addresses exactly what's alleged in this. Yeah, just so we're very clear that this statute has a specific punishment provision, which is if there's serious injury or death of a child. So when you look at that statute, initially it doesn't have it within the punishment provision. It makes it a felony in order to, if in fact a death occurs. And again, this court has just addressed that just this year, within the past couple of months, that's not the basis for felony murder, because we have a very specific statute that addresses this provision. And we have a specific statute, we can't charge the general statute. And what the state has done with count 3 is charge this general statute of felony murder, and that's just inappropriate. Right. The death is incorporated both in the allegation and the indictment as well as in the offense. We're asking to be lesser included.
Argument.
And I believe they've done it in counts, this is for count 3?
Yes.
Yeah, and that's based on, okay.
And
it
it's
can't be
charges
3.
13 and 14.
Yes, and so, Judge, I don't believe this is a lesser included offense. I'd look at Slack versus the state, 265 Georgia Appeals 306. These are offenses that while they could be indicted separately, we have chosen to indict a charge of contributing to the deprivation. That could have been well within our bounds. As you know, in several cases, felony murder based on cruelty, there are also charges of contributing to the deprivation as well. And then it would be possibly a sentencing issue later about what would merge into what. However, here we've got 2 separate offenses that have each separate elements in the case. For instance, in cruelty, we have the element that has to be proven of cruel and excessive physical pain, which is not included in this statute. And in this statute, the deprivation, we have willfully commits an act or fails to act, which would cause a minor to be adjudicated to be dependent. And then there are other elements included in that as well, Judge, which are not included in the cruelty to children and the elements so far as count 3, as it's alleging criminal negligence in that count. So, Judge, I believe that these offenses do not, there is not a lesser included here. So I would ask you to deny the defense's requests 13 and 14 as well.
I think it's very, I think it's very instructive that the state says we could have charged this, but we didn't. That's the point of our asking for this. Certainly they could have, they didn't want to because they wanted to get a higher punishment. That's exactly what the Williams case just said, I believe it was last month, that you can't do that. You don't get to choose to do that. The rule of lenity makes very clear. If in fact we do have, by leaving him alone, that's making him dependent. The cruel and excessive physical pain, that's in need of protection of the court. That's exactly what the statute has, and it foresees that this could happen where a death occurs. under the state's theory, that would always be cruelty to children, and thus this statute has no meaning. That's not what they meant. They wanted to have a particular statute for death of a child, and that's why we think it's applicable.
Well, I don't think it's applicable. I do think that these got dropped at 2 o'clock this afternoon and it's 4:30. So I don't anticipate giving it. Now I'll do some research and take a look at it. We can readdress it. We're going to readdress one of them on Monday anyway. But my inclination is, it's not supported by law or fact. But I won't close the door completely.
Thank you, Your Honor.
It's just not very open. All right, we've done our task for the afternoon. I see the car seats here,
Yes.
and it can be delivered to the clerk.
Yes, Judge. Investigator O'Connor go out to the secure copy. Get state 307, excuse me, and I'll return that to clerk.
And I appreciate that. And we'll be here for your closing arguments. Verdict forms, you all have said that as they stand without any lesser includeds are acceptable to both sides, I believe. As it stands right
correct.
now, I'm not giving lesser includeds. Monday we'll come back and I've reserved, lesser included homicide by vehicle in the 2nd degree, defendant 6 through 9. Maybe 10? 9. And then, yeah.
That's right.
And then, 13 and 14, we can talk about some more if you want to. And if I grant any of that, then we'll have to relook at the verdict form. Fair enough?
Thank you, Your Honor.
Anything else for the state before we adjourn?
No, Judge.
For the defense?
No, ma'am.
Well, y'all promised a full day and you delivered. All right, we're in recess, 8:30 Monday morning. Argument, charge. And it will probably be lunch before I get the written portion I'm going to give to the jury, and I'll give it to you all, and between argument and charge, I'll let y'all look at it and see if there's any tweaking. The jury doesn't necessarily have to have it while I'm instructing them. I can give it to them later. So we're not under the wire. I don't intend to give it to them until they go out to the street. I don't want them reading it as I'm instructing, because it may not all, I may not give every little bit in the charge. Some of the performance things I'm not going to do. So, everybody have a good weekend.
You too, Judge.
Judge.